United States, the state of Florida.
Good morning. Be seated, please. We have just two cases remaining on our calendar for this morning. We'll hear those two cases in the order in which they appear. The first case is DJV, Inc. versus the Department of Financial Services. Is counsel the appellant ready to proceed?
Yes.
Please come forward.
Please the court. I'm Susan McLaughlin. I represent the appellant DJD. I'd like to reserve 3 minutes for rebuttal.
All right.
And I'd like to proceed to cover what I think are the highlights of our case without prejudice to anything that remains in the brief that I don't get to. I'd like to start out with the constitutional issue by stating what I think the statute does allow and what is constitutional. On April 2nd, 2004, the Division of Workers' Compensation conducted a site inspection at a single-family residential construction site where Mr. Walega, who was my client's subcontractor, was laying carpet. My client had a contract with the general contractor that was on the site. General contractor had insurance, which included insurance for statutory employees. Mr. Walega had proof of exemption that appeared to be in force until October of 2005. But because of a change in the law that was effective January 1st, 2004, that exemption became invalid because Mr. Walega had failed to incorporate and amend his exemption to reflect that he was an exempt corporate officer. The compliance officer issued a stop work order against Walega. I believe that was constitutional. They also issued a stop work order against my client. And the stop work order under Section 440-107, presently 107A, is allowed, but allowed only for the site in question where the violation occurs, and only during the duration of the violation, which had ended because the department had stopped Mr. Walega from proceeding. My client was otherwise insured through a leasing company for the employees that it had. Its other subcontractors who were installing floor covering were insured or exempt. There were no other existing violations. I believe that the statute 440-107A and 107, presently 107-7.
Counsel, in regards to your constitutional arguments, given the legislature's express pronouncement that an employer's failure to comply with the workers' compensation coverage requirements poses an immediate danger to public health, safety, and welfare, how is your right to due process violated by the stop work order ended?
Well, I believe that it does have the right to stop work when there's a violation in progress, but once the violation has ceased, I believe that Section 107-7A, 440-107-7A, does not permit the ongoing stop work order. It does not permit a stop work order that applies to all my client's locations, including its showroom, its store, its warehouse, and other locations where properly insured employees were working. I believe that the stop work order was overbroad. Also, if the stop work order that was issued against my client had assessed a $1,000 fine, which I believe would be the appropriate fine for the single violation that was uncovered as the result of the site inspection, my client could have paid the $1,000 fine and gone back to work in an otherwise legal manner. But that's not what they did. What they did was they issued a stop work order without a specific fine that could be paid. And if you'll see, it's on A1 of our appendix. It was an either-or, either $1,000 or the amount of insurance premium that was avoided. Well, for one day work for Mr. Walega, the maximum fine would have been $1,000. Plus, my client did not avoid insurance premium, which is another one of our arguments. What they did was they hired a contractor that they thought had a valid exemption, but the department had issued an exemption with an incorrect expiration date. They issued that in October of 2003.
Counsel, didn't your client have constructive notice of change in the law?
I guess you could impute that to them, but they didn't have actual notice. It's a very complicated law. Don't forget that the legislature does not require all businesses in Florida, or even all businesses in the construction industry, to insure themselves and their employees. There are many, many exceptions. And one of the things I think you should keep in mind is the fact that the penalty for running afoul of the exceptions has to be in line with what's involved. This is not a crime of moral turpitude. The exception applying to the construction industry and the exceptional exception applying to independent contractors in the construction industry runs upstream of all of the law and logic on point. While you might impute notice to my client that the law changed and that the piece of paper that the division issued with an incorrect expiration date.
Well, at the time it issued it, that was under the current law at that time, correct?
Yes, but it wasn't going to be, the exemption was valid when issued, but it wasn't valid through October of 2005, which is what it said on its face. It was only valid till January 1st, and that's one of our arguments. The division made an error there with the expiration date. If the expiration date had said January 4th, 2004, then my client would have been on actual notice of the exception. Plus, they didn't avoid insurance premium by failing to insure Walega. What they did was they hired a contractor whose paperwork wasn't in order. Mr. Walega, had he done what he intended to do and what my client thought he had done, would have paid approximately $100 to incorporate himself and paid nothing additional to amend his exemption to reflect that he was now an exempt corporate officer. He did not avoid insurance premium. But at any rate, had the department fined my client $1,000 for having someone on the job without the correct exemption, they could have paid that and moved on, but that's not what they did. They issued a stop work order for all of my client's work sites, including a warehouse and a showroom and other work sites where legitimate work was going on, no other violations in process. My client was required to produce its books going back 3 years, together with proof of insurance and exemption for any subcontractors or insurance for its employees. It was able to do that rather promptly, which is unusual in itself for a small business. And a week later, the department issued not a new order based on the audit, but an amended order relating back to what I believe was the initial illegal order, unauthorized under the statute, under Section 440-107-7. A, presently A. During this time, my client's entire business was shut down, placing them in default of their obligations to their contractors. There was never a situation where any worker was in danger of being without insurance because my client's client, the general contractor, had insurance on that work site. After being shut down for a week, my client was faced with a fine involving over $127,000, which under the law applicable at the time had to be paid in full for it to get back to work. And the department relies on additional authority, the Riopelli case. I don't know if I'm pronouncing that right.
Counsel, in regards to the authorities, why don't our decisions in Aruba versus Gold, Crest Kitchens, Smith versus Larry Rice Construction, and Armstrong versus Almond in the Pines apply in this case?
I believe that there is a conflict in the decisional law, although not necessarily the statute. I'm aware of those cases. First of all, they are not compliance cases. The contest there was between an injured worker who was, by the way, contending that he was not an independent contractor.
Already construed the definition of employee to include sole proprietors, even if they are also independent contractors?
That doesn't make that person my client's employee. The question is whether my client's an employer. I call your attention to 3 sections that are involved here. 440.02.15d1 defines independent contractor. As of January 4th, 2004, the independent contractor included the 9 or so items that are really questions of indications that my client would not be in control of their business and activities.
But we don't even get to those 9, do we, in the construction industry?
No, not now. As of January 1st, 2004.
Did we prior to January 1st? I thought that the case law of Aruda and Armstrong, I thought that those cases said the same thing, that we don't get to those 9.
No, what those cases said, and with all respect to the court, I think we're in error. What those cases said was that under 440.02.15c, which deals with sole proprietors and what they have to do to be exempt. Now, keep in mind, outside the construction industry, a sole proprietor is presumed to be exempt. Inside the construction industry, before January 1st, 2004, a sole proprietor had to register notice of exemption or notice of corporate officer exemption. After January 1st, 2004, two changes. First, under 15C, 440.02.15c, dealing with sole proprietors, there's no such thing as a sole proprietor in the construction industry. You have to be a corporate officer to be exempt. But at the same time, 440.02.15d1, dealing with independent contractors, added another clause. Even if you meet all these other criteria, establishing your independence and lack of control from the general contractor or intervening contractor in this case, you still can't be an independent contractor if you're in the construction industry unless you're a corporate officer, basically, is what it says. But that throws you not into 15C, but into 02.15a, making you an actual employee. And I call the attention of the court to its other decisions on this point, natural landscaping. And this deals with, and this is where I think the department is confused. First of all, a subcontractor has nothing to do with the issues in this case. A subcontractor, that term is under 440.10. 440.10 defines when my client's responsible to provide insurance. The allegation in this case is a violation of 440.10a, which is the obligation to insure your own employee, namely someone who falls under 440, the definition of employee under 440.02.15a.
So, counsel, can you distinguish the facts of this case from our prior decision in Aruba? Or are you suggesting that we not follow the Aruba decision?
I cannot, yes, I can distinguish it, but by reason of the context of the case. First of all, in those cases, we had an injured employee who was claiming he was the employee of the defendant in the case. The court, I believe below in Aruda, the workers' compensation judge had awarded benefits on the basis that they were not independent contractors, and the defendant was appealing on that basis. And this court in those three cases held that it didn't matter because if he doesn't hold an exemption under 440.02.15c, he's an employee. Well, he's an employee of himself, not an employee of my client. And the court admitted in these three cases that the law is unclear.
If that's the rule, I mean, if I understand your argument, excuse me for interrupting, but what you're in essence saying is we have an independent contractor, and we have a statute that says that you are an employee unless you are exempt. And even then, you had to be exempt since 1991 or something. And you're saying that he's merely an employee of himself? I mean, isn't that the same situation?
Again, I think I cannot completely distinguish my case except to say that this has not been the holding in a compliance context.
You're not saying Mr. Wega, under the workers' comp statute, is an employer of himself, are you?
Yes, he is. A sole proprietor, an exempt sole proprietor in the construction industry doesn't have to have an employer. Suppose the homeowner had hired Willega directly.
But he's not exempt.
He's not exempt. But in a scenario, I believe that these three cases are in error and are not necessary. First of all, they admit that there's a conflict in the statute. A conflict in the statute is resolved in favor of an injured party. But a conflict in the statute is also resolved in favor of someone who's being assessed a penalty. So the presumptions are different, number one, in our case. Number two, I believe that the court, and with all respect, is in error in that case. And in natural landscaping, dealing with the same situation.
You're well into your rebuttal time, but if you want to wrap up, we'll reserve 3 minutes for you that you requested.
Okay. I didn't get to my part about the fact that the penalty was assessed. Again, my client did not avoid insurance premiums. Also, on the Willega situation, the estoppel issue, the judge, the ALJ made the necessary findings for to find in my favor on estoppel, but he never addressed the issue because he thought the exemption didn't matter. I don't understand that argument. I believe there was an error, and the only penalty that was assessed after 1104, which, by the way, why was that amendment necessary if the court's interpretation of the law in the Aruda and those cases is correct? It would not have been necessary. Also, the department did not raise that until after the hearing, which I think was unfair. And that's it. I'll have to wrap up and take my time. Thank you.
It's your time. If you want to use the balance of your time, you can do that. Actually, you used 15 minutes, but
Okay.
we've had problems with the clock, and I did indicate that you could have 3 more minutes. So.
I only have 11:35
Well, I
here.
know. I say there's a problem with the clock.
Okay. All right.
You've actually used about 15 and a half minutes. But
I'm sorry.
But since we've had a problem with the clock, we'll give you 3 minutes.
All right. Well, I also wanted to address the Riapelli situation.
Riapelli,
Riapelli,
I think is the way that's pronounced.
Riapelli.
If you want to go ahead and address that now, you can, but you understand you're using your rebuttal
Okay.
time. Go ahead.
Just 2 points on that. In Riapelli, the penalty was $2,200, a summary offense or misdemeanor. In our case, the penalty was the equivalent of being convicted of a felony, tried and convicted. The other thing, the right to go into court and get an injunction or get an accelerated hearing, it doesn't matter if you're out of work. If you've been out of work for a week, a small business is out of business. Finally, if you look at the department's own position, their own investigators, not only in this case but in a related case that's before the court, have testified that if they thought these people were independent contractors and the payments were prior to the effective date of the changes in the law, that they would have excluded them, but they just required us to go into court and proved it. And then when we did that, they said, oh, we're going to our fallback position, which they know there's a problem with the statute. It's unclear. And I believe if it's unclear in a penalty situation, you have to find in favor of my client. Thank you.
Good morning. May it please the Court. My name is David Hawkins. I'm Assistant General Counsel with the Department of Financial Services. I'd like to address 2 points, both that Judge Lewis and Judge Hawks mentioned, and that had to do with the context of ARUDA and what it means here. Quite frankly, the ALJ, in deciding the case, focused solely on one subpart in the definition of employee in the workers' compensation law. That subpart declared that an individual who satisfies the 9 criteria of independent contractor is not an employee. That part isn't difficult. What is difficult from the department's perspective and what it reversed the ALJ on in its final order was the fact that there is another subpart of the same section which clearly states that an employee who is a sole proprietor in the construction industry must have an exemption or is going to be an employee. And that's precisely the principle that was elaborated on and developed in the ARUDA line of cases. I don't see how the argument that ARUDA was not a compliance case.
Dan, counsel, why should we apply our reasoning in ARUDA?
Well, in part because exactly. In part because the facts are indistinguishable, and 2, because they interpreted the section of law which applies to the facts here, and 3, because there hasn't been any indication in any of this court's logic or any other district court's logic that would suggest that the provisions of 440 in the administrative realm ought to be ruled upon and viewed any differently. Moreover, under 440.015, the legislature has clearly and expressly said that the law shall be interpreted consistent with statutes and understandings of rules of construction, but shall not be liberally interpreted in favor of either the employer or the employee. Doesn't draw a distinction between a benefit side case and a compliance side case. So at this point in time, that particular principle you're alluding to has not been articulated in any of the court's case law. The department was confident in applying ARUDA and has for a number of years in other cases that I've cited in my brief. Moreover, Ms. McLaughlin has on occasion recited or referred to the screenshot, the photocopy of the department's compliance systems monitor. which appears as Respondent's Exhibit 1 at Volume 2, page 331. That is not, by any stretch of the imagination, a certificate, nor does it have any description which would put anyone on notice that that there was an exemption issued to an individual for a particular period of time, but for the entry under the phrase expired. And there it says that as to Mr. Walega's exemption, that it expired on 10/29/2005. That is purely and simply a part of the calculation that the system goes through. When it is fed information, it automatically then would include 2 years from the date that the exemption application was approved. And in this case, testimony was that Mr. Walega was instructed and informed by department personnel that that was not true, that there was a change in the law which made void, effective January 1st of 2004, any of the exemptions that were currently pending at that time.
Counsel, doesn't Section 440.0215D say that independent contractors who meet the listed criteria are not considered employees?
That's correct.
Then why should the appellant be penalized for not having provided coverage for them?
Well, in part because 440.02 has other language in it. And indeed, if you go to paren C of the 2000 version of the statute, it specifically says that partners or sole proprietors actively engaged in the construction industry are considered employees unless they elect to be excluded from the definition. That, coupled with the Arruda line of cases, suggests that the department was eminently correct in its decision making. And it's a matter of recognizing that while the two sections appear to be in conflict, there are ways of reconciling that are straightforward and easily understood. But simply to dismiss and read over or read out of the statute 440.02 paren 15 paren C is mistaken. And that's the controversy that the department found itself in with the ALJ's ruling, and specifically overturned them for having failed to acknowledge or recognize that in Arruda. I would like to just spend a minute talking about a panel decision that came out 2 weeks ago in Reappel.
Before you get to that point, in regards to the appellant's estoppel argument, why shouldn't the department be stopped from finding the appellant given the date of Mr. Walega's exemption?
2 reasons. One, under the theory that the date entry in the expiration field on the department's form was wrong. It was wrong as a matter of law because the legislature said so. The legislature had voided any exemption that was pending effective January 1st of 2004 and required the exemption holder to meet certain criteria and reapply in order for that exemption to be effective after January 1st, 2004. And as you're aware, the statute narrowed the scope of persons who could qualify to individuals who were officers of corporations actively engaged in the construction industry, and would not have included an automatic opportunity for Mr. Walega, a sole proprietor in the construction industry, to have an exemption after January 1st. The department has maintained in its brief that that was a mistake of law. If it is alternatively viewed as a mistake of fact, then DJD is in an awkward position now because it's essentially asking this court to allow it to substitute its version of the facts for the facts that the ALJ relied upon in declining to accept its view. The ALJ rejected DJD's argument below that the department should be stopped from denying the existence of a certificate for Mr. Walega. So on both of those arguments, I think the DJD's position is somewhat untenable. If I may begin with...
Why is DJD the one that's fined?
DJD was an employer. DJD had employees, and DJD did not have coverage for those employees.
But why is he a statutory employee of DJD?
Why is who, Mr. Wallega?
Yeah, I mean, hasn't Ms. McLaughlin argued that if he in fact had fallen and gotten hurt, that the general contractor's insurance would have had to pay?
It's possible, and in the construction context in particular, where you've got a number of layers of individuals that are present on the site, once you determine the relationship, it's possible that there could be more than one employer. And in the context of the general contractor who subcontracted to DJD, who in turn subcontracted to Mr. Wallega, there's a hierarchy in there. But Mr. Wallega was indeed DJD's subcontractor and employee.
So he would have been able to go to their workers' comp,
Correct.
and then he would have been able to go to the general's workers' comp.
If it were available, that's correct. But the penalty scheme will not allow one of those entities in that chain to evade the coverage obligations.
So they've run the risk of the penalty by entering into a subcontractual agreement with him.
That's correct. Without having coverage or making sure that Mr. Wallega, as a subcontractor in the construction business, had an exemption. And as the testimony showed, DJD, perhaps to its credit, more than many other employers, attempted to require the subcontractors with whom it had engaged to produce those kind of records.
But you had 9 of these employees that you discovered, correct?
That's correct. If I may quickly hit Reappel, it certainly is a very compelling case from the department standpoint. And the quotation in here from the district panel's consideration and review of the due process argument, which is similar to the due process argument here. In Reappel, the employer sought to challenge 44107 on the basis of the fact that it didn't provide a pre-termination hearing, i.e. an opportunity to have a fact-finding adversarial proceeding before the stop work order, or an immediate one after the order. Unlike Reappel, DJD's challenge is based solely upon the failure to have a pre-termination hearing. They did not argue that there was a post-termination deprivation under the due process clause. But Reappel's panel cites very strongly to Mitchell versus W.T. Grant and Company, which is a United States Supreme Court decision in the mid-70s. Due process does not require a hearing before the possession of property is disturbed, but that a full and immediate hearing must be made available before one is finally deprived of his property. That's enormously important in terms of the logic of how this court views 44107 and the department's compliance initiatives. What I would ask this court to do, as I did the Reappel court, would be to consider as well the application of Matthews versus Eldridge. Unlike Mitchell, unlike Sniadak, unlike Fuentes versus Shevin, this case is slightly different. Those Supreme Court decisions applied the due process clause to evaluate statutory schemes that affected one individual's interest in recovering the value of a contract or the value of property sold under a conditional sales agreement from a debtor. So there were, on balance, separate competing private interests. In contrast, this case has as a significant player the state of Florida and its keen interest in preserving the health of the workers' compensation system. And because of that, I believe that Matthews versus Eldridge sets out a more sound paradigm for evaluating the competing interests of the state when there are exigent circumstances and there is a threat to the general welfare, as the legislature in 2 sections in 440 have declared, that when an employer violates the coverage obligations of 440, it presents an immediate threat to the general welfare sufficient to justify the department's issuance of a stop work order. So in that respect, I would ask if you would take a look at my brief from the standpoint of seeing if Matthews versus Eldridge doesn't measure up, and perhaps the 2 cases very soundly then would punctuate the importance of and the depth of this court's due process analysis.
Why $137,000 fine? Are you out of time?
We're down to 124, actually.
Well, why $124,000 fine?
Well, because that's what the statutory scheme prescribed.
What about Ms. McLaughlin saying that you could have imposed a $1,000 fine?
Then we would not have been enforcing the statute as the legislature prescribed. The legislature in this case prescribed and says shall, not may, says shall assess a penalty for the value of the evaded premium, which is at 1.5 times the premium. And in that respect, there's no discretion.
So you could not have imposed a $9,000 fine or a $1,000 fine or something?
Not in correctly administer the law. If there's no questions, I'll conclude, and thank you very much.
All right, thank you. Ms. McLaughlin, you have about a minute and a half remaining for rebuttal.
As far as the independent contractor issue goes, I submit that you can't resolve Section 15C and 15D1 and 15A. They're in conflict. The court says that in Arruda. You can't resolve that with the way that the department treated corporate contractors, which were eliminated from the calculation. Don't forget, a corporation has to have at least one employee. Again, Justice Hawks hit on this when he said they really treated Waliga as a statutory employee, not a real employee. This court in Natural Landscaping and Sunshine Ace Hardware, cited in my brief, has indicated that the question of a statutory employee is not involved in this context. Also, you can't resolve the way the department wants you to view the situation with the way they treated Waliga. They stopped him from working and issued a penalty against him. If he was just someone's employee, he wasn't in violation of the law. You can't resolve the department's interpretation of the independent contractor situation with the amendment to the law that became effective January 1st and the fact that they amended the independent contractor provision under 15D1. They didn't just amend Section 15C, as the department maintains. Finally, on the reappel situation, we are contending that what was unauthorized by the statute was a stop work order of all my clients' business everywhere in Florida, not just the site where the violation was, and I think 107.7 clearly limits their authority to that, as well as the fact that the cases cited by the department and in reappellee I don't think apply. The cases cited in my brief, Wilson and Linkhouse, I think they apply to the facts, and the blanket stop work order was not legal either constitutionally, nor was it authorized by statute. I don't think the court has to find the statute unconstitutional. It's what the department did here that's unconstitutional. Thank you.
All right, thank you. Thank you both.